thank you, and unquestionably an inflationary introduction, and I thank you for it. Suffice it to say, Cato is the place to be if you're a serious privacy hawk and you want to have discussions about these important issues. And so, Julian, I really appreciate your having me for this program, and I think obviously with Eric and Michelle, you've got two veterans of the surveillance discussions as well, and I think you're going to have a good program. Let me, if I might, because we've got votes coming up, give you my sense of where things are for a few minutes, and then I told Julian we'll throw it open to questions. Softball questions are always especially welcome at this point in the congressional calendar. But let's talk a little bit about where things are, and particularly the events of last week. To me, the importance of the events of last week are essentially twofold. The first is, last week was the first instance where the government has admitted that there is a violation of Fourth Amendment privacy rights that has taken place. That's essentially the first significant news from last week. The second part of those news is this is the first time that the government has stated that the FISA court has reached the judgment that the spirit of the FISA Amendments Act has also been violated. So these were the important findings, in my view, of last week. They came about largely because I asked the intelligence community to declassify statements that I believed were true. I asked them in a classified way, so you get a sense of how sensitive and arduous the task is to constantly push these efforts to declassify documents and have some transparency and have some accountability is. So I submitted them in classified form. I asked that they be declassified, and the two statements that I've given you reflect essentially what the government was willing to declassify, that for the first time they've admitted that there's been a violation of the Fourth Amendment constitutional right to privacy, and also for the first time they have said that, in their view, what the FISA court has stated, that the FISA Amendments Act, the spirit of the law, has also been violated as well. So this, in my view, sets the backdrop now for an important debate that I hope is going to take place in the fall. I'm going to do everything I can to advance in the fall. The FISA Amendments Act, as all of you know, is up for reauthorization in the fall. I have put a public hold on the bill. It is my long-standing policy. Actually, Senator Grassley and I authored the proposal, which eventually became law, requiring that senators who put holds do it publicly. But even before that, it was my long-standing policy to announce that I was putting a public hold on a piece of legislation I felt strongly about. I have done that with respect to the FISA Amendments Act, and with that, there will be an opportunity for a real debate in the fall. And I think the two disclosures that I've cited that were made last week, I think sort of sets the table for a different kind of debate. I can just tell you from the standpoint of putting my cards on the table as we begin, I think before this law is reauthorized, the public ought to be able to see more information about its impact on the privacy rights of law-abiding Americans, one, and I think protections for the privacy rights of law-abiding Americans needs to be strengthened. So that's sort of how I come to this in terms of what I'm working on as it relates to what will be on the floor in the fall and the backdrop of what happened last week. Now, let's spend a couple of minutes so that everybody at least is square in terms of what the background is here and how we got into this place. As you all know, if a law enforcement agency has a compelling bit of evidence that an American is a serious criminal, the officers go to a judge to get a warrant to tap that individual's phone. And anybody who watches The Wire or NCIS, you kind of got a pretty good idea already of how all that works. Now, what people sometimes forget is that the police officers on these shows, and of course in real life, are building on something that the Founding Fathers thought was sacred ground, and that was the Fourth Amendment, what was a bedrock principle that the government couldn't violate Americans' privacy with unreasonable searches and seizures. So in effect, if you wanted to get a warrant to search somebody's house, you had to show a judge. You had to show a judge that there was probable cause that you would, after the search, find evidence of a crime. Pretty brilliant concept. As usual, Founding Fathers got it pretty much right because it simultaneously protects individual privacy, while at the same time saying to the government, when you believe that there is evidence to believe that a criminal is engaging in something that threatens public safety, the government's in a position to have a process to proceed. Now, to me, the next part of the discussion starts really in the 70s with Congress passing a law to govern wiretapping for intelligence purposes. That, of course, was the FISA legislation. It allowed the government to get a warrant for somebody if there was evidence that that person was a spy or a member of an international terrorist group, even if they had not committed a crime as yet. It was based pretty much on the same concepts of warrants, probable cause, and it, of course, continues to be used today. After 9/11, the Bush administration decided that it needed additional surveillance authorities. They said, we've got to have additional surveillance authorities beyond what is in the FISA statute. Now, unfortunately, instead of asking the Congress to change the law, the Bush administration came up with a warrantless wiretapping program that, as we've come to know, operated in secret for a number of years. This, of course, like everything else, as I constantly tell my colleagues, eventually becomes public, and there was a huge uproar. And many of my constituents certainly were livid when they learned about the warrantless wiretapping, program, as were people on the Hill. So at that point, there was a pretty passionate, debate. Congress passed the FISA Amendments Act of 2008. That replaced the warrantless wiretapping program with new authorities for the government to collect the phone calls and emails of those who were believed to be foreigners outside the United States. The centerpiece of that act, and a big part of my concern, is a provision that has come to be known as Section 702 of the FISA statute. That's the provision that gave the government the new authorities to collect the communications of people who are believed to be foreigners outside the United States. And unlike the traditional FISA authorities, and unlike the wiretapping authorities, it did not involve requiring that law enforcement and intelligence officials obtain individual warrants. For this reason, it contains language that is specifically intended to limit the government's ability to use these authorities to deliberately spy on law-abiding Americans. Congress also put an expiration date on these new authorities. That was designed to make sure that there would be ongoing and continuous review. And, of course, that next expiration date is December 2012, which is why I have put this hold on the legislation that has passed out of the Intelligence Committee and will be debated undoubtedly in the fall. So, when Congress comes back in the fall, the question is going to be, should the FISA Amendments Act be renewed as it stands, or is it appropriate to make reforms? And Senator Mark Udall, another strong privacy supporter, is on the committee. We tried to, in effect, kickstart the debate last summer, asking questions about the law's impact on the privacy of Americans. In particular, Senator Udall and I focused on the fact that since 702 was targeted at people outside the United States, it was our argument that it was important for Congress and the public to get an understanding, really a rough understanding, of approximately how many people inside the United States have had their private communications collected under the authorities. And my sense is it's not hard to figure out, what the issue is. If only a handful of people inside the United States have had their phone calls and emails collected under Section 702, then I think Americans walk away and say there's not a substantial question of their privacy rights being in jeopardy. On the other hand, if a large number of people inside our country have had their communications collected and reviewed under the statute, then I think people are going to walk away and say, hey, hold on here. Maybe this is a law that needs to be reformed, and protections for the privacy rights of Americans ought to be strengthened. So after that, really in last July, Senator Udall and I wrote to the Director of National Intelligence, and we said we'd like an estimate. We would like an estimate of the number of Americans who've had their phone calls and emails collected by our government under these new authorities. And the response we got, and I'll quote here, is, it's not reasonably possible to identify the number of people located in the United States whose communications may have been reviewed under the authority of FISA. So you can probably imagine Senator Udall and I didn't think that was a particularly helpful, response. We made it clear that we were not after a precise count of how many people have had their privacy impacted by 702, but that it ought to be possible to at least get a rough estimate of how big this number is. So last month, in what is really one of the more remarkable statements I've heard in my time in public service, the leadership of the NSA said that trying to come up with this estimate would in itself violate the privacy of U.S. persons. Now, you kind of scratch your head and, you remember the days when people said to save the village, you had to destroy it, and that sort of thing. But even by Washington Alice in Wonderland standards, this seems kind of far-fetched. How exactly does it violate privacy rights to give a ballpark estimate of how many people have had their communications swept up in that? So I've been pretty outspoken about my saying I don't think that passes the smell test, and we are going to press for more transparency on this point, and I hope we'll be able to persuade intelligence officials that more needs to be shared with the public, and to expect Americans to say that even a ballpark estimate of how many have had their communications swept up somehow is an offensive violation of individuals' privacy, that is just too far-fetched even by Washington kinds of standards. Now, let me be clear. If there is no estimate of how many Americans have had their communications collected under the law, it's possible that the number could be quite large. I mean, that would make the case for why you need to have strong rules to protect the privacy of our people. Unfortunately, we're not able to make that judgment now because we don't have that number. So, when you don't have it, you can say, well, looks like if it's very large, that suggests that the laws are inadequate to protect people's, privacy. And yet, if you don't have it, you're really sort of stuck in place trying to figure out how to proceed. In addition, there is another concern that we have about a loophole in the law that can allow the government to effectively conduct warrantless searches for phone calls or emails of a particular American. And let me explain how this works. And again, it's because of the wording of the statute. No one can say whether it's been done or not. It involves the wording of the statute, which our plain reading of it says it could be happening. All of the communications collected under Section 702 are collected without individual warrants because this authority was intended to be used to target foreigners outside the country. But if the government wants to search through all of the communications that it has collected under Section 702 in an effort to find the communications of a particular American citizen, there is no requirement to get a warrant to do that. That is the plain reading of Section 702. There is no requirement in the law to get a warrant to do that. In my view, searching through warrantlessly collected communications in an effort to find the phone calls or emails of a specific American, in effect, would be a backdoor warrantless search of that American's communication. I don't believe the law ought to allow this, and I think the backdoor searches loophole ought to be closed, and I'm going to do everything I can in the FISA amendments reauthorization this fall to close that loophole. Now, I think it's fair to say not everybody in the United States Senate agrees with me at this time. The Senate Intelligence Committee said in a report last month, and I quote, "The Department of Justice and the intelligence community reaffirmed that any queries made of Section 702 will be conducted in strict compliance with applicable guidelines and procedures and do not provide a means to circumvent the general requirement to obtain a court order before targeting a U.S. person under FISA." I, as you might guess, disagree with the Department of Justice and the intelligence community on that point. In my judgment, backdoor searches of this nature would absolutely circumvent the traditional warrant requirements laid out in other parts of the law, and certainly in the Fourth Amendment. I want to be clear. If the government has clear evidence that an American is engaged in terrorism, espionage, or serious crime, I think the government ought to be able to read that person's emails and listen to that person's phone calls. In fact, my own view is that's an essential part of protecting our country from terrorism. So, when the Intelligence Committee was considering the FISA Amendments Act last month, Senator Udall and I offered an amendment that would have prohibited backdoor searches of phone calls and emails collected under Section 702, but it specifically would have allowed the government to search for an American's communications by getting a warrant on that American or by getting an emergency authorization when you were dealing with a time-sensitive matter. So our government would have allowed, our amendment would have allowed the government to search for an American's communications if the American people were believed to be in danger or if for some reason the American consented to the search. It didn't pass, but just this last week in the Senate, it was offered in the Senate Judiciary Committee by a conservative Republican, Senator Mike Lee of Utah. It has not, passed yet, but I think it's an indication, again, that you are starting to see a spark of life here in the United States Senate around these issues, around the sense that it's time to step back and take a look at the constitutional teeter-totter again. The Founding Fathers really got it right. They said, by way of this constitutional teeter-totter, over here is collective security, and over here is individual liberty. And as we proceed in this wonderful place known as the United States, keep them in balance, we'll be doing just fine. But with the government now admitting, as they did, last week, to me, that there has been a violation, of the Fourth Amendment constitutional, protections. The constitutional teeter-totter is a bit out of balance. And I think that's why in the Judiciary Committee and the Intelligence Committee, you're seeing efforts to strike a better balance. Now, I'm sure some of you sit and say, hey, they came back and redid the FISA legislation, and you thought the warrantless wiretapping, program was over, that there was going to be a court to review all of this. Now, it is a court. It's called the Foreign Intelligence Surveillance Court, usually known as the FISA Court. It was set up by the original FISA statute to review applications for wiretapping warrants under FISA, and it's made up of federal judges. They serve for fixed terms. Now, it's important to note that while this court reviews traditional probable cause warrant applications made under the FISA law, it is not charged with reviewing individual acquisitions of communications made under Section 702. It's charged with reviewing the government's procedures for acquiring communications under Section 702, whether they're reasonably designed to target foreigners and exclude people who are inside the United States. The court also is charged with reviewing the government's procedures for handling any information that is collected under the FISA Amendments Act and trying to determine whether what's called minimization procedures are being handled properly. So the court doesn't just stamp yes or no on the government's warrant applications. Sometimes they do other things. They issue rulings on what the law means. And the problem, in my view, is that unlike federal courts, they operate in total secrecy, and nearly every ruling they make is classified. So normally, if you want to know how the government and the courts interpret a particular law, you just go look up the case, the significant case that you care about, and you get to learn most of what you need to know. But obviously, if everything is classified the way it is in the context of FISA, that is not, the case here. So I have been trying to bring attention to this as well, and as I see it, it's appropriate for intelligence agencies to conduct secret operations, what are in effect, called protecting sources and methods. But I don't think the government ought to keep public laws secret. I mean, it ought to be possible when you go to your iPad and you look up a law to know that that law you're reading is what is being used to guide the government's interpretations, and that there's not a big gap between the public law and how the government is actually interpreting it. But that has been the case, and we have been pushing for changes here as well. In 2009, the Department of Justice and the Office of the Director of National Intelligence, after we pushed very hard to get more transparency on the process, agreed to establish a process for identifying and redacting and publicly releasing FISA court opinions that contained legal interpretations, not matters that related to sources and methods and was important to protect, but legal interpretations. But here we are, 3 years after that was agreed to, and absolutely zero has been accomplished. Nothing has no redacted opinion has been released. So that's where we are in terms of kind of the major picture. And I have been trying to get the Director of National Intelligence to start declassifying some of the key statements about how the court, has ruled. Director, Clapper, I think, is seeing that the current situation is, indefensible, and I think that's one of the big reasons that he sent me the letter declassifying the material I asked for, last week. So, hot off the press, finally a declassified, document. The FISA court stating that the collection carried out under the Section 702 process, in their view, is reasonable. It is true that on at least one occasion the FISA court held that some collection carried out under the law was unreasonable, and that my judgment that the government's implementation of Section 702 has sometimes circumvented the spirit of the law. The Director Clapper, is acknowledging that on at least one occasion the FISA court has reached the same conclusion. So, those are in the world of intelligence where you are fighting and clawing to get some measure of transparency, are at least some new and important facts to begin with. Supporters of reviewing the FISA Amendments Act without changes continually say that the government is careful about how it uses the authority, careful not to intrude on the privacy rights of law-abiding Americans, but now in a declassified document based on what I got last week, the government has said that is not always the case. That is not always the case any longer, and I think the public is going to say that's significant. Now, I can't get in to really saying much more about secret court opinions. I'll also note that the director's office in the communication last week said that the government has remedied the constitutional concerns raised by the court, and the court, in again quoting from the letter, continue to approve the collection as consistent with the statute and reasonable under the Fourth Amendment. I will tell you my opinion that the government still has not addressed the concerns that the implementation of Section 702 has sometimes circumvented the spirit of the law, and that is continuing to go on today. So the question then becomes, where will we be in terms of the fall? The Senate and committee rules regarding classified information generally prohibit members of the Congress from discussing what intelligence agencies are actually doing or not doing. I do believe that I've got an obligation to discuss what intelligence agencies should or should not be doing and what our nation's intelligence laws should or should not be doing. And I believe that searching for Americans' phone calls and emails without a warrant is something that the government shouldn't do. So I'm going to keep working to increase, transparency. I'm going to point to Section 702. I'm going to say the government is not saying that it can conduct these backdoor searches without, a warrant, but when you read the plain text of Section 702, it could be happening. And that's why I think that this debate in the fall is going to be one of the most important in years. I hope that some of you will join us in terms of advancing this cause. That's why when I came in, I said if I'm looking for privacy hawks, I'll try to find my way to the Cato neighborhood, because this is a place that has put a great priority in these issues and making sure that people understand in something resembling English why they are so important.